Why wouldn't they just put it in a trust? So this was a reply on a comment where someone was explaining that their mother had executed a deed where she added her grandchildren onto the deed as co-owners with rights of survivorship, assuming in order for this property to pass to them when she passed away without going through probate. So this is an excellent question. Why not just put it in a trust? So oftentimes a trust will be one of the best, if not the best options under the circumstances. However, as with most things in estate planning, what you're going to do with your real property will vary from person to person depending on several different factors and your unique situation. So sometimes a trust may not be the best option, or it may not even be a workable option. So I'm just going to run through a couple of those examples, and this will sort of highlight why it's important to meet with an estate planning attorney before you decide what is the best option, because they may be thinking with things that you're not. So the first thing I'm going to discuss is, of course, the trust itself is a little bit more advanced in estate planning. Now, depending on how complex the trust is, but a trust, even in its simplest form, is always going to cost more than a deed. So oftentimes I do see people who choose to either add people to a deed or to execute an enhanced life estate deed or a Ladybird deed instead of doing an entire trust for financial reasons. Now, there's a lot to be said on spending more now so that your children or your beneficiaries don't have to spend more down the road. But there are situations where a Ladybird deed listing one or maybe two individuals may be a viable option rather than a trust. So as an example, let's say you're a homeowner that has really not many assets, some bank accounts, easy to put payable on death recipients on those accounts, and a homestead or a real property. And that's really all your assets. And maybe you only have one child. So in this instance, because you can easily list your child as a beneficiary or POD on your accounts, and the only other asset is your home, you may want to consider doing a Ladybird deed, as that may be enough, depending again on the circumstances. Now, you might want other documents, because it's also important to have documents that pertain to what happens while you're alive, but you may be incapacitated. Things like a durable power of attorney or a healthcare surrogate, a living will. However, you may not need to also get a trust. And again, for people with financial considerations, this might be a good option. Another option I'm going to discuss that I don't see very often because it's kind of unique, but it is an instance where maybe just adding someone to the deed, like this person was talking about in the comment, may be the best option. So what if a child is already living with their parent and plans on staying in that home as their primary residence, continuing to live there after their parent dies? So if the child's living in the home, doesn't plan on going anywhere, right? So it's going to become their primary residence. One thing to consider is what happens when property passes to a child, either through a trust or a Ladybird deed or through probate, if you didn't have either of these. What happens to the taxes on that home? So when an individual owns a home and it's their primary residence in Florida, you're allowed to claim a homestead tax exemption. And what this does is effectively caps how much the property taxes on the home can go up every year. So it caps them out at 3%. You only get this cap if it's your homestead property. However, if the child is already living in the home and it's their homestead too, then they would qualify for homestead the same way a parent would. Now, the interesting thing about homestead is it cannot be passed down to your children. So your children do not get the same benefit of the homestead property tax exemption that you received during your lifetime. This can be passed to a spouse. It cannot be passed to a child. So when your child inherits the property, although they might get a step up in basis if they sell it and not have to pay capital gains taxes, they will not get your homestead tax exemption. They will have to reapply, or apply themselves, I should say, for this homestead tax exemption if they're planning on making the home their primary residence. They will receive the exemption, but it will be based on the new value of the home that's going to be assessed at a higher value, of course, because when you bought the home, whenever it was, it could have been way lower than what it's worth when your child inherits it. So they're going to be basing their homestead tax exemption off the new appraisal from the county, which again is most likely going to be at a much higher rate than when the home was bought and you initially got the homestead exemption. So in this instance, it may be wise to add your child onto the deed while you're still alive and the taxes are what they are, again, if this is the child's primary residence, because they could also apply for homestead on this residence, carry that same homestead exemption if it's a joint tenants with rights of survivorship deed and your child survives you, then they would inherit the home and just go on living in the home as they have, for as long as they wanted to. So these are only two examples, but I want to highlight the point that although it's not wrong to be thinking with why not do a trust, because again, oftentimes a trust is a really good option and oftentimes the best option. It's not the only option and it's not the best option for everyone. So again, this is why it's really important to meet with an estate planning attorney before you decide which way you're going to go, because it's a lot easier to do things correctly the first time than to have to pay the expense to redo them or to undo them and do something different in the future, or worse yet, leave your children with a big mess because it wasn't done right when you could have paid a little bit more to do it right. All right, so if you're in Florida and you have more questions about deeds or trust, estate planning, or elder law, and you want to reach out to our office, we're at Cause Law Office, the non-stuffy attorneys, and the link is in my bio.